Welcome to my channel Advocate Club. So today we have seen CPC definition clause. The definition under CPC section 2 subclause 2 is decree. So today we have tried to discuss decree under section 2 subclause 2 and decision which are decree, decision are not decree. The list also given by me by end of the lecture. So started. Firstly, we have seen the definition of decree given under the CPC Code of Civil Procedure 1908. A decree means a formal expression. What is a decree? Decree means a formal expression of an adjudication, which so far as regards the court expressing it conclusive determine. How it is determined? It is conclusive determine the rights of the parties, and it define rights of the parties with regard to all or any of the matter in controversy in the suit. Any of the matter in controversy in the suit, and may either preliminary or final, both kind of decree, whether preliminary or final. It shall be deemed to include. It means deemed decree. Okay, deemed decree. What kind of decree is deemed decree? A decree is deemed decree to include. First one is a rejection of plaint. Order 7, Rule 11 of the CPC define rejection of plaint. And second deemed decree is determination of any question within section 144 of the code. It means restitution of suit, section 144. It is also a deemed decree. Actually, it is also not a decree. It just create a fiction of the law. Order of the nature of rejection of plaint and determination of question under section 144 may not strictly fall within the four corners of the definition of decree, but by legal fiction they have been conferred the status of decree. Therefore, it is a decree. A decree does not include the following. What? First one is any adjudication for which an appeal lies as an appeal from order. And second one is any order of dismissal for default. It means DID. Okay, it means DID. So that two are exceptions and not included in decree. Another point, essential element of decree is adjudication of court. Adjudication of court is the first essential element. Second one is formally expressed. Formally expressed. Third one is given in suit. In the suit, the court given this third essential element given in the suit. Such adjudication must have been given in the suit. The adjudication must have determined the rights of the party. So first essential elements is rights of the parties. Such right must be with regard to all or any of the matter in controversy. So 5 essential element is controversy. The adjudication must be conclusive and final. What kind of adjudication? Conclusive and final adjudication. So this is the essential element of decree. Adjudication, it means is a judicial determination. What does mean of adjudication? It means judicial determination of the matter in dispute. If there is no judicial determination, there is no decree. Such judicial determination must be by the court. The court. So second essential element of court. Okay, court defined under section 3 of Indian Evidence Act. Indian Evidence Act, as we know, Okay, and what is defined? The code word defined includes all judges, magistrate, and all person except arbitrator legally authorized to take evidence. So what is exception? Exception is arbitrator. And suit. What is a suit? Suit also defined. Suit is not defined in CRPC. But Hansraj Gupta versus official liquidators case, suit means the Privy Council held that civil proceeding instituted by the presentation of plaint. What? The presentation of, okay, we can take another page. The presentation of, sorry, okay, the presentation of plaint to proper authority. It is a suit. It is decided by Privy Council in the case law. And the right of the parties, as we seen, right of the parties. So what kind of rights? The term rights means, the term rights means substantive rights only. Substantive rights only. And not procedural rights. Procedural right are not include. Sorry. Procedural rights are not include in the rights definition. Only substantive rights are includes. And conclusive determination, as we have seen in the definition of decree, it's mentioned conclusive determination. It means determination must be final. Determination must be final. So final determination is necessary. If not final decided, the right of the parties finally is not a decree. Okay. Formal expression also a word. All the requirement of formal expression must be fulfilled. Okay. Formal expression. These are the essential elements of our decree. The formal expression must be given in the manner provided by law. So decree having kinds. The decree having three kinds. First one is, what is types of decree or kinds of decree. So decree having three kinds. First, second and third. What is this? First one is a preliminary decree. Preliminary decree. Second one is a final decree. Okay. Third one is a partly preliminary and partly final. Partly preliminary and partly final. So this is the three kinds or types of decree. Section 2, subclause 2 of the Civil Procedural Code provides that a decree may be preliminary, final, or partly preliminary and partly final. Preliminary decree means determines the right of the parties with regard to some or one of the matter in controversy, but does not completely dispose of the suit. Does not completely dispose of the suit. Disposed of the suit. Therefore, it is a preliminary decree. And what is a final decree? Final decree means completely dispose of. Completely dispose of. Okay. A final decree is one which completely dispose of the suit and settle all the question in controversy. Nothing further remain to be decided. This is the final decree. Depend on the preliminary decree and not. It is vice versa. And partly preliminary and partly final. The such kind of decree are passed in certain cases. For example, for possession and mains profit. In such cases, court direct the possession of land and orders inquiry into the profit. The first part of the decree is final, whereas the second part is preliminary. Since the decree is one, it is a part preliminary, and one another part is a final. So possession means profit, inquiry into the profit. It is two part into profit. Okay friends, and cases in which preliminary decree may be passed. As we need to know, preliminary decree passed in the cases of specifically, first one is Order 20, Rule 12, suit for possession and mains profit, possession and mains profit. Order 20, Rule 13. We can take a list of preliminary decree. Okay friends. Second one is Order 20, Rule 13. What it says? Administration suits. Third one is suit for preemption. Order 20, Rule 14. It is dealing with suit for preemption. It is the cases where preliminary decree may be passed. And fourth case is suit for dissolution of partnership. Order 20, Rule 15. Next is suit for accounts between principal and agent. It is a Rule 16 of Order 20. Suit for partition and separate possession. Rule 18, Order 20. And suit for foreclosure of mortgage. We have seen Transfer of Property Act. It defined foreclosure under Section 67 of Transfer of Property Act. It is here the suit for foreclosure of mortgage procedure under Order 34, Rule 2 and 3. It is also preliminary decree. Suit for sale of mortgage property. Order 34, Rule 4 and 5. Suit for redemption of mortgage. Order 34, Rule 7 and 8. What is this? Order 34, Rule 2 to Rule 8 dealing with mortgage property. Mortgage property. Okay. So such kind of property or such orders dealing with preliminary decree. Okay. Order 20 and Order 34. And rules of 13, 14, 15, 16, 18 of Order 20 and Order 34, Rule 2, 3, 4, 5, 7, 8 dealing with mortgage property. And it is that such kind of properties is only preliminary decree. Appeal from preliminary decree under section, defined under section 97. Okay, under section 97. What is this? Appeal from preliminary decree. So it is appeal. Section deals with appeal. This code provides by a preliminary decree does not appeal in such decree. He shall be precluded from challenging it in appeal from the final decree. Okay friends, the object of section 97 is to prevent the preliminary question being asked at later stage when the suit has been completely decided. A final decree is depend on the preliminary decree. What is it? Such kind of final decree is depend on the preliminary decree. So if an appeal against preliminary decree succeed, the final decree falls. Therefore, the section 97 says no appeal. And now we have discussed the last part, which is decision which are decree. Okay, what kind of decision are decree and decision which are not decree. That is very important for MCQ, any competitive examination where your subject is CPC. Therefore, we have seen a list of the decision of decree, which is decree and which is not a decree. First one is abatement. It is a, okay, we can change color. Right. Decision which are decree. So abatement decision is also a decree. Discharge of some defendant in ground of was not for cause of action, it is also a decree. Dismissal of appeal, time barred appeal dismiss, then it is also a decree. Rejection of plaint, as we seen in our decree definition also, the rejection of plaint is included decree, it is a deemed decree. And modification of scheme section 92, it is also a decree. Order holding appeal not maintainable, it is also a decree. Dismissal of suit against him holding defendant as wrongful implication, it is also a decree. Dismissal of an application for final decree. Order setting aside auction sale, it is also a decree. Nullity on the ground that deposit was not made on date of sale, deposit not made on date of sale, it is also a decree. Granting of refusing of grant to grant cost, it is also a decree. And the decree which is not a decree, decision which is not a decree, is an order refusing to stay. Dismissal in default, as we have seen, the definition of decree itself says what? Dismissal of default, it means DID is not a decree. Order refusing to set aside sale, it is also not a decree. Setting aside rejection plaint, remand for fresh trial, and appeal passed by appellate court under section 151 of the code, return of plaint, rejecting of the application, sui forma pauperis, refusing leave, institution of suit for account of religious endowment, an order appointing a commissioner to take accounts, order 26 dealing with commissioner, it is also not a decree. Decision in favor of plaintiff, question of limitation, jurisdiction and res judicata under section 11 of CPC, it is also not a decree. An order of appellate court returning a memorandum of appeal to be pretended to be a proper court, it is also not a decree. Order passed in execution proceeding. And last one, an order on the applicant third party to add it as a party, it is also not a decree. So such all kind of things are not decree, friends, not a decrees. Deemed decree, what includes? We have seen as deemed decree is a term used create a statutory fiction, so it is rejection of plaint and restitution of suit under section 144, it is deemed decree. Otherwise this remaining all decrees are not a, all decisions are not a decree. So it is important, you can read and see. Okay friends, thanks for watching. Bye bye.